Welcome back to the channel, guys. Hope your preparations are going as usual very good. So this particular video will be very quick and crisp. It is about all the amendments which were released for your May 24 attempt. There's no special amendments which are applicable for your September. Whatever that are applicable for May will continue for September also. There are only two specific amendments which are given. We'll go through them very quickly. So let's get into the video directly. So we have amendments regarding two sections, section number 23 as well as section number 89 and 90 combined together. Speaking about section 23 first, I'll give you the background so that you understand the concept of amendment very easily. So what happened in section 23 was private placement and public offer. We have divided the companies under Companies Act into two categories, right? A private company and a public company. Remember, the private company can raise finances in three different ways. They can raise finances either by way of a private placement, or they can raise finances by way of a concept called as a rights issue, or under a concept called as a bonus issue. So private placement, rights issue and a bonus issue, that was something where a private company can raise finances from any of the options. Then moving on, a public company can raise finances from actually four different options. One is your public offer and the rest three is private placement, rights issue and a bonus issue. So one additional concept which is added for a public company was raising money from public. Raising money from public always involves a huge amount of procedure and huge amount of compliances to be followed with, because along with the Companies Act, the provisions of SEBI also apply for the process of raising finances from public. We have to get our securities listed. We have to make sure that our securities are available for the process of trading on the recognized stock exchanges. This was a logic, basic introduction of how to raise money from public at large. So whenever you're raising money from public, it will be applicable with the provisions of Companies Act as well as the provisions of SEBI. So this was a logic on how to raise finances in India. Now the central government by notification have added two more subsections, subsection 3 and subsection 4, into this section number 23, which states that the very first amendment for us, this is subsection 3 and subsection 4 has been notified by central government, stating that in the future, remember this is not been notified as of now, in the future the central government has a power to notify certain class of public companies to raise certain kind of securities from a stock exchange, not in India but in a stock exchange located in a jurisdiction outside India. That means they are trying to raise the money from a area or a country which is located outside India. So whenever you want to raise money from India, we have already made rules and regulations under Companies Act and SEBI. Now if you want to raise money from a jurisdiction outside India, you can still do that, but it will be applicable to only certain class of companies and only by issue of certain class of securities, where you can raise money by listing your securities on a recognized stock exchange located where outside India. But as of now, the central government has not given any notification. Now go through the important points here. We're gonna apply this logic to certain class of companies, and it will be applicable only for certain class of securities where we are getting them listed on a stock exchange located where, on a foreign jurisdiction located outside India. And this notification is not yet given, may be given in the future by the central government. Based on this notification, after the notification has been given by central government, may further provide that certain class of companies will be exempted from certain provisions of this Companies Act. These are the four different categories which are exempted here. First, your chapter number 3, this chapter prospectus and allotment. Then chapter number 4, that is your share capital and debentures. Then your section number 89 regarding beneficial owners, and section 90 regarding significant beneficial owners, and 127 regarding the process of punishment for non-declaration or non-payment of dividend within 30 days. These are the few sections which are not applicable to certain type of companies by the notification given by central government. So in a nutshell, what is amendment here? Central government by notification provide that certain class of companies by issue of certain type of securities can raise money by listing their securities in a foreign jurisdiction. Those certain class of companies which are notified can also be further exempted from the provisions of certain things. First is your prospectus chapter, then is your share capital and debentures chapter, chapter 3 and chapter 4, then section 89 and 90 regarding beneficial owner and significant beneficial owner, and the last process regarding 127 punishment for failure to pay the dividend within 30 days of declaration. These are the few sections which can be exempted. Now, coming to the exam perspective, this section 23 cannot be asked as such because there is no notification from the central government as on today. But in the future, there will be adding a notification. Only thing that can apply for your exam is an MCQ, which states that whenever a company wants to raise money from foreign jurisdiction, the notification will be drafted by whom? The answer would be central government. That's your first notification under section. Moving on to the second amendment, we have this amendment under chapter management and administration, chapter number 7, where we have seen the provisions of section number 89 and section number 90. Section number 89 was a process where the Companies Act states that you, the person who have beneficial interest, or if you are acting as a registered owner for some other person acting as a beneficial owner, come and declare everything to the company. We'll do a legitimate transaction here, declare everything to the company will maintain it in a separate register. This was a process where you have to on your own come and declare it to the company. If you fail to declare under section 89, there comes the logic of section 90, where the company starts sending notices to the beneficial owners. Now the section 89 states that wherever we receive declaration, the registered owner has to send their declarations to the company, and at the same point of time, the beneficial owner shall also send their declarations to the company, which was happening in form numbers MGT 4 and MGT 5. Once these declarations are received by the company has to forward these declarations to the ROC. So there was always a communication between the company and ROC regarding all the beneficial interest existing in that particular company. Now the Companies Act states that for the process of this communication between ROC and the company regarding the beneficial interest of shares in that company, we will designate a particular person who will be responsible for these communications. We'll forward all the communications to the ROC, who will extend his information to the ROC, will appoint a person, a separate person designated with the responsibilities for furnishing and extending information to whom? Information to the ROC. And the Companies Act stated that who must also be appointed as this designated person. States that designated person who must act as a designated person, a company secretary. But appointing company secretary is not mandatory for all the companies. If at all you are a company for which the logic of company secretary is not applicable, then in place of that company secretary, you will appoint any other key managerial person as a designated person. If at all you don't even appoint a key managerial person, if you don't have a key managerial person and this provision of key managerial person is also not applicable for the company, then we state that every director of the company will have a responsibility to submit information to the company, on the failure of which will also impose penalties on these persons. So what are the three criteria of people? This will be done on a hierarchy basis, so we should remember the order here properly. First comes the company secretary. If he is not appointed in the company, then the powers are given to a key managerial person other than company secretary. If he is not also there in the company, then we'll have the provisions given to every director of the company. Now this was a people who has to be designated by company. Company has to actually make rules and regulation to provide them powers, responsibilities of communicating with the ROC, furnishing and extending their information to the ROC. And until the company makes this designated person appointed, the Companies Act states that these set of people will automatically act as a designated persons. The first, company secretary if appointed. If not appointed, this time the powers are given to a managing director or manager. If these two directors, managing director and manager, are also not appointed, then the powers are given to again every director. Understand the points? These have to be designated by the company. If not designated, until they are designated, these people will automatically be deemed, assumed to be designated persons. Who are the three criteria again? Company secretary if appointed. If not appointed, managing director or manager of the company. If there is no company secretary, if there is no managing director, if there is no manager, then every director of the company. And all the details of this designated person so appointed shall be mentioned in their annual return. Remember, annual return under section 92, we have to submit documents to ROC. This annual return will mention the details of the designated persons. And finally, the details of these designated persons have to be submitted to ROC also. And in the future, after appointing this designated person, if there is any change in the details of the designated person, obviously it must also be informed to the ROC, and it has to be informed in form number GNL2. What do you mean by this GNL2? We have always seen the forms MGT, management and administration. We have seen the form DPT, deposits. We have seen different forms INC, incorporation. We have seen the forms PAS, prospectus and allotment of securities. So basically form numbers are always based on the chapter's name, but wherever we have requirement of forms and there is no chapter covering these logics, we have forms called as generalized forms, GNL. GNL2 is used for the process of communicating to the ROC the change in the details of the designated persons. Hope this crisp video is enough for you. If you have any further doubts on any of these two amendments, please do leave a comment on this. We'll see you on the next one. Thank you guys.